A warm good evening to everybody. Today we will start with a favorite topic of mine, that is drafting. Now, drafting is something which is very important for a lawyer whose complete life in the court depends on the drafting, because you may be arguing the matter, but before that you will require a draft. If you don't have the draft, it will be really difficult for you to argue the matter best. This is my thinking over the all these years experience. So I will always tell that whenever you make a draft, make it a point that you cover everything, because you may argue in the court, and later when you leave the court, what remains in the court is the draft prepared by the lawyer. So always remember, drafting is one of the important part. Now the juniors who enters this field really find sometimes how to draft, and whenever they go for drafting, it is not simple like how we used to write the applications in the college life. It is completely different. Or whenever we go to the police station, that is also very simple draft. But when you go to the court, it is actually there is some format which you have to follow. And even if there is no format, suppose there is a writ petition and public interest litigation, there is no such format. But that doesn't mean that you can write anything. There is a title, there are facts written, there are prayers, which is very important part. Now, prayers remind me that I have written a book, namely Courtroom Prayers, which is available on Amazon. Now, this book poses all the drafts, that is from the Supreme Court till the High Court to the Supreme Trial Court. I could have covered few drafts, that is about 38, but I would request all of you to go beyond that. Drafting cannot be compiled or cannot be confined to one book itself. There are big lawyers and big firms who have come up with very good books. So you should go through all the books to know what is good drafting. Now, the basic ideas about drafting I will give you. The best you can do is start reading the any lawyer's draft. Now, any lawyers mean wherever you are practicing, if you take the drafts of the opponent lawyer or your own senior, that will give a brief idea how to draft, because you will have at least a procedure, at least know the contents of the draft. So always remember, there are many applications. If you go in the criminal, it is exemption application. It is application for adjournment, that is we are seeking time from the court. Also, there are applications for warrant, summons, substitute service of summons to take out the notice, calling show cause notice from the police station. So this will go on. In every, in High Court also we have civil application, criminal MA. In Supreme Court also interlocutory application. So everywhere these applications, petitions, writ petitions, then complaint copies, written statement, everything comes around drafting. So it's 50%, or I would say more than 50% legal work comprises of drafting. So always remember, drafting is the most important part. Now here the juniors find it difficult sometimes. How do I learn the drafting? The easiest way, one I told, that read the old drafts of lawyers who are senior than you, and you can request them that I may be allowed to go through your briefs. Or sometimes the opponent lawyers also files very good draft. You can learn from the opponent. Never leave an opportunity to learn from opponent lawyer as well. Now, secondly, I would say the best teacher, like Eklavya, we can go through the judgments. Now online there are many judgments available. So if you try to read the High Court judgments, or the trial court judgments are not readily available everywhere, but the High Court judgments are readily available. If you go through the High Court judgments, you will have an idea, because the contents of the drafts are mostly mentioned in the application, in the judgments, as well as there are sometimes some opponent who has taken the points, or who has said that I'm opposing this application, I'm opposing the prayers asked by the plaintiff or the petitioner. These are the points you will get. So you will also get an idea that what not to draft or what grounds not to take. So always remember that you can learn from the opponent. So never leave an opportunity to learn from the opponents as well. So drafting is something which you can learn from all the corners in the legal parlance. Now another drafting which I would request all of you to go through some old books. There are Moga's book. There are many books which are available. If you go to library, the librarian, if he's an experienced librarian, he will always tell you, this is the pleading and drafting book. Please go through it. or never go through a book which has just simple format. Go through books which has commentary. Now the commentary book helps you to draft to the point, and also to allow you to go through many judgments. Now, if you go through these judgments on the commentary part, you will always know that what mistakes you should not make. Whenever you read a judgment, you get 2 points. One, that is of the petitioner, another that is of the respondent. In criminal trial, also that is of the complainant, and another it is of the accused. So you are getting the information from all the sides. So judgment is one such group, or we are Eklavya like us, that we can learn from anything. It's not necessarily always you should have the father or mother. If they are not lawyers, your first generation lawyer, then you may not have a good amount of briefs at your office or home. So it's always the good thing that I would request all of you to read judgments, especially the trial court and the high court, because high court covers the wide area. Never remember that. Never say that I'll only go through Supreme Court judgment. That is not, that shouldn't be done. If you, there are more than 26 40 high courts around with all the benches in our country. If you go through the judgments of each high court, even one single judgment a day, you will have an idea. You can make the note of the same. And secondly, you will also know the prayers part. You see, the prayer part is very important. What prayer you're seeking at the end. Because if you write the complete draft and at the end of the, see, judge may see the, what are the prayers you're seeking from the court. You may write your story, you may write the law, but what prayers you're seeking from the court, what is the relief you want from the court. So always remember to write the prayers specifically properly. If the prayers is not mentioned properly, if you need custody of the child, mention that. If you need maintenance from the husband, you write that. If you need any other relief from the court, you have to write it. You want dissolution of marriage, you want restriction of marriage, everything you should write which section properly in a proper way. Drafting is one important part where the prayers are included, and in the, if in the course of the your drafting, if you don't put a specific prayer, because you may have the complete draft and the court, if you say court that my petition may be allowed, what is the prayer you're asking? That is the first question will be posed to you. So drafting is best learning for the new lawyers who have joined here. I would say, if you know the drafting, 50% of your work is done. 25%, it all depends on the how you present the case, and 25% sometime it says it is said in legal parlance. Sometimes it depends on the luck of the clients also. But 75%, remember, 50% drafting and 25% is your presentation, your argument, your persuasion of the matter. So always remember that drafting is very important part. I'll ask Vandana to share a book written by me. In the picture she will share. But this book is confined to pure drafting. It is a very big, vast experience which you will gain over the years of practice. As you grow in practice, you will know how to draft. You will also know how to improvise it. And there, if the drafting is good, 50% of your work is done. So I will wait here for the Vartika to read the judgment. That is second part of today's session. Vartika, unmute yourself.
Yes, ma'am.
This is a judgment of Supreme Court by Justice Santosh Hegde. This judgment is about the appreciation of the evidence. Vartika, I'll be reading the first part because I need to tell something to the people who are attending this. The appellant herein and his father were charged of an offense punishable under section 302, read with section 34 IPC before the district and session judge, Jodhpur, on an allegation of having committed the murder of Devendra Raj Singh, who was a tenant in the building owned by the appellant's father. During the pendency of the trial, the father of the appellant, Haji Mukhtiar Ali, died. Hence, the trial as against him abated. See, here, father of the appellant, there were two accused. One accused died during the trial. The word used, trial against him abated. Now, application for abatement. Now you will know when the application for abatement is made, when one of the accused or any accused dies, you have to bring it to the court's notice. That is why I'm requesting all of you to read the judgments. Whenever you read judgment, you will get some insight and you will improve on the legal knowledge as well. Vartika, the facts of the case are not that necessary.
Yes, ma'am.
If you can read from the, according to PW 14, if you can you see this?
Yes, ma'am. Yes, ma'am.
Start reading from here.
Okay, ma'am. Shall I start? Okay, ma'am. According to prosecution witness 14, when he arrived at the spot of incident, prosecution witness 15 and his staff were already there. And after noticing the dead body and getting some information from the people present there, he came to know that prosecution witness 1, the brother of the deceased, was in his own shop nearby. Therefore, he proceeded to the said shop. By the time prosecution witness 14 reached the said shop, prosecution witness 1 had written down a complaint narrating the incident that had taken place. That complaint, which was subsequently marked as exhibit plaintiff 1, was given to prosecution witness 14. Based on that, a case was registered. When the said complaint was given to prosecution witness 14 by prosecution witness 1, it contained only one part giving details of the incident, and at the end of the report, the signature of prosecution witness 1 is found. But before this report was sent to the police station, prosecution witness 14 asked some questions, answer to which were recorded in the later part of the said complaint. Exhibit plaintiff 1. This is where we notice that the investigation agency has played a role in roping in the appellant herein in the crime. In the first part of the complaint, prosecution witness 1, after narrating the incident in detail, stated, as soon as we reached near the shop, Abdul Wahid said to his father that they instigate all tenants and do not let anyone to pay the rent. Upon this, Haji Mukhtiar at once shot at my brother. A reading of this complaint does not show that the appellant had instigated or exhorted his father to shoot. This is the first document which came into existence after incident. The author of this document was none other than the brother of the deceased, who was in the company of the deceased and had witnessed the incident. If really the appellant had a role to play in the murder of the deceased, prosecution witness 1 would not have forgotten to narrate the part played by the appellant in exhorting his father to kill. As noted above, after exhibit plaintiff 1 was given to prosecution witness 14, a second part was added to the same, which is also dated 23 of August 1991 at 5:15 p.m. at Chopasni Road. That part reads that the report was submitted at the place of occurrence by Mr. Anil Kumar Singhvi, and on oral inquiry, he disclosed that gun was single barrel and that when he and his brother reached at the shop of Haji Mukhtiar, appellant Abdul Wahid said, "Father, shoot them." At that time, Haji Mukhtiar shot the gun. Herein, we notice that a very important improvement is brought about at the instant of prosecution witness 14 by showing an exhortation by the appellant which is not found in the first part of the complaint. We see that this was done at the instance of prosecution witness 14 because prosecution witness 1 in his evidence when questioned about the same stated, I gave the report exhibit plaintiff 1 because exhibit plaintiff 1 written by me,
P1,
which is
P1.
in
It's
P1,
not
which
it's a criminal case. Prosecution, it is prosecution P. It is a P1.
P1 written by me, which is in my hand and bears my signature from A to B. Chan Singh inquired from me as to what had happened when I told him about the above mentioned incident. He made some notes on the report exhibit P1, which is from C to D, and took my signature from E to F. This clearly shows that prosecution witness 14 got the latter part of the complaint recorded because in the main body of the complaint there was no overt act or role attributed to the appellant. This inclusion coupled with the omission of nothing and overt act on the part of the appellant in the Fard Bayan exhibit P8 recorded by prosecution witness 15 clearly indicates that at that point of time, till the said addition was made at exhibit P1, there was no allegation of overt act on the part of appellant. It is in the above background, we will have to consider the oral evidence led by the prosecution to prove the charge under section 34 of IPC as against the appellant. Prosecution witness 1 in his evidence stated, when we went at the shop of the accused person and the accused Abdul Wajid said to his father that Pitaji, these are the persons who instigate the tenant and do not allow anybody to pay the rent, shoot them. Prosecution witness 5, who accompanied the deceased, and prosecution witness 1 to the shop of the accused in his evidence stated, XXX Abdul Wahid entered this shop and said to his father Mukhtiar Ali that Pitaji, these two instigate our tenants should them. In the cross examination, he clarifies this statement in the following words. Abdul Wahid said to his father to fire the gun. Only this word he used, shoot these two. Name of Devendra, Anil or anyone else had not been mentioned. Prosecution witness 6, another eyewitness in his evidence stated this: as soon as Abdul Wahid reached, he went inside and said to his father, these instigate the shopkeepers, allow none to pay the rent, shoot them. Saying this, having gone inside the shop, he shooted near the counter. Haji Mukhtiar Ali was standing inside the shop holding gun. In his cross examination, he states that Abdul Wahid stood and beckoned with his eyes, and after the beckon, Haji fired the shot. Prosecution witness 7, another witness who speak about this part of the incident in his evidence stated, Abdul Wahid while entering his shop said, Pitaji, shoot them. They instigate the tenant, do not let them pay the rent. But in his cross-examination, he stated Abdul Wahid had said naming Devendra Raj shoot Devendra Raj. Abdul Wahid had not taken name of Anil for shooting him. We find a considerable discrepancy in the above statement of prosecution witnesses 1, 5, 6, and 7 in the language used by the appellant to exhort and the manner and the place where the said exhortation was given. Learned counsel for the appellant pointed out that the use of the word Pitaji by the appellant itself indicates that these witnesses have been tutored or to make this statement because it is not the language of the Muslim to address his Pitaji, his father as Pitaji. This thing could only have happened when a witness is wrongly tutored by somebody. We found some force in this contention. The two courts below did not take note of the fact that original complaint as well as the Fard Bayan Exhibit P8 did not contain any allegation of an overt act by the appellant, and the same was included for the first time by way of an addition to Exhibit P1 at the instance of prosecution witness 14. The courts below, however, did not note the discrepancies found in the statement of witnesses as to the exhortation or the language used in regard to the same. The trial court, however, took a very curious view to reject this discrepancy on the following basis. I find that contradictions as mentioned above have crept in the evidence of the witnesses, But such contradictions are natural when generally witnesses are not produced in the court after fully tutoring them or excessively lengthy cross-examination is conducted. I do not find any such contradiction in the evidence of the witnesses, which may be said to be absolutely fatal to the reliability of the prosecution story. We are not prepared to contribute to this theory of lack of proper tutoring or excessively lengthy cross-examination as observed by the trial court. Suffice is to say that if only the court below and had taken note of manner in which this overt act was attributed to the appellant in Exhibit P1 and an omission to allege any such overt act to the appellant in this Fardbayan Exhibit P8, these contradictions would have had much more serious effect on the appreciation of evidence of the said witnesses. The High Court, though, took note of the fact that prosecution witness 1 in the earlier part of the complaint, Exhibit P1 did not attribute any overt act of the appellant, brushed aside the same by saying that it is possible that the fact slipped from his mind when he was writing the FIR. It also observed, however, immediately after he handed over the FIR, he recollected and disclosed this fact to Chan Singh, the accused Abdul Wahid had made an exhortation to his father. We do not think the High Court has properly appreciated the content of Exhibit P1, nor has it taken into consideration the manner in which this addition came to be made in Exhibit P1, about which we have already expressed our opinion. If only the High Court had noticed this fact, then, in our opinion, it would not have brushed aside the discrepancies found in the evidence of prosecution witnesses 1 and 4 to 7 as non-fatal discrepancies. Taking into consideration the entire facts as found on record of this case, we are satisfied that the prosecution has failed to establish the alleged exhortation by the appellant, and the court below have erred in accepting the prosecution case in this regard. The appeal is allowed, setting aside the impugned judgment and conviction recorded by two. Ma'am, can you
courts
please?
below. The appellant is on bail. His bail bond stands discharged.
Ma'am, it is not visible.
Okay, no problem. Now,
Thank
you, Vartika. Very well read. What Vartika read, if we could have percolated what she was reading, there was a cross-examination, there was abatement, there was appreciation of evidence. Now, one thing I would like to point out from here, there was a Muslim person, and Muslim person will not address his father as Pitaji. That is one thing which is brought to the counsel of the appellant to the notice of the court. It was brought to the notice of the court at the Supreme Court level. And the Supreme Court appreciated the fact that the witness may have been tutored. See, this is one small thing. There may be many more things which we can go through while investigation. If you read the complete judgment, which Vartika did read, I didn't only allow her because due to paucity of time, I couldn't read the facts of the case. But what we have understood that if we bring the facts of the case, the cross-examination, the appreciation of evidence to the court's notice, it is highly possible that we can get the good orders in favor of our client. So always remember, it is how you appreciate the evidence brought before the court, how you bring it to the court's notice. That is why I always request people to read the judgment, those who are from the legal field. Now, next part is also related to what I'm going to speak, that is about the examination chief. Now, everybody knows what is cross-examination. I would say cross is the easiest thing, and the examination chief is the most difficult part, because this is where the foundation is laid on the for the cross-examination. So always remember, what is examination chief is the complaint filed by you, the petition filed by you, the FIR filed by you. That is just a filing. That is just a drafting. But the trial goes on. What is trial? Is when you give the evidence. Now the cross-examination will not start just directly. the public prosecutor or the complainant's lawyer or the petitioner's lawyer will put up a foundation of the petition or their facts before the court. Now, this is very difficult because the counsel or the lawyer is not allowed to lead the witness. Now, the witness, what is the meaning of witness cannot be led? Witness, I cannot put my words in the witness' mouth. He has to be prepared. So always remember, whenever you go the court from the petitioner side, complainant side, always you have to, it is not tutoring, it is refreshing his memory. It is preparing for the examination chief. And your examination chief should be so perfect that there is no room for the cross examination. Now, the practical aspect I will discuss here about the examination chief is that whenever you are preparing a witness for the examination chief, always, if it is a criminal case, find out from the complaint what he has stated. Don't put extra anything in the complainant's mouth or complainant's evidence which is going to speak before the court. You cannot lead. You can only guide the witness. You cannot. What happens? What is your name? What is the incident has taken place? He has to narrate. That is the responsibility of the witness. The counsel of the complainant or petitioner or plaintiff cannot come in the shoes of the witness. It is the witness responsibility. What has happened? The reason behind that witness cannot be led in the examination chief because the court wants to know the truth. If I am guiding the person, then he may speak something which is beyond, he may exaggerate the facts. So always remember, the court wants that the truth should come out, and truth is not required to be remembered. That is the proverb we have heard, we have learned, and this is what if any police station go कि सच को याद करने की जरूरत नहीं है, आपने सुना होगा. So always remember कि जब भी आप whenever you are leading leading the evidence in examination chief, it is, I would say, not use the word leading, in fact, guiding the witness. Then always remember what are documents. Never put other facts. And if you're putting the other facts, remember there should be some room in the FIR or in the complaint. If it is not there, you cannot bring the new facts. Otherwise, it will give room for the cross-examination at length and you may lose the matter. Here, what happens? The witnesses were tutored in the Abdul's case, which Vartika has read judgment of the Supreme Court. And he spoke Pitaji. Now, this word, the accused were Muslims. He will never say, it may be some other words he will be addressing as father. And these words, the court perfectly found out from the evidence that it is a tutored witness and they lost the prosecution lost the case. Now, how do we learn the examination chief? It is an art. The best part, I would say, go to the court. In the criminal matter, the public prosecutor, he has the most best example of examining the way he will guide the witness for going for an examination chief. So if you sit in JMFC court or any other court for that purpose, the best part you can learn from the examination chief is from the through public prosecutor, which I have done in my juniorship because they have a lot of cases and they prepare it so well that it is really actually sometimes difficult for us to cross-examination. So always remember what is written in FIR, one rule, what is written in your complaint, he should be speaking that, stick to that. If he improvises, then there will be questions in the cross-examination. So always the examination chief should be so perfect and so properly done that it should only connect with the FIR and the what he has spoken. There should not be any difference between two versions. That is the facts narrated in your complaint or petition or the FIR and also the words spoken, the facts narrated before the court. If they are cut to cut properly done, ditto, then it will be really difficult case for the counsel of the accused or the respondent to cross-examination. So always remember that in cross-examination, the counsel can travel beyond the evidence also sometimes. They can bring the other facts on record also. But then examination chief is something which is the narration of the fact which has actually taken place. So it is about the truth. It is one of the important part And it is actually sometimes neglected. Examination, the people take it very easy, but no, that is the foundation of your case. See, the complainant's petitioner's case always depends on the examination in chief. This is what for today. Anybody have any question or want to say something? We have 5 more minutes. You can unmute yourself or write in chat.
Good evening, ma'am. This is Shraddha.
Hi, Shraddha.
Hello, ma'am. I'm from Mumbai and I'm a last year law student. I wanted to share one of my experiences when I visit session court. You have just mentioned about the cross examination and examination in chief. And I was lucky to witness the examination in chief and the cross examination about the case. And as you say, it was a great learning experience because at a lower courts, you always know how to plead, how to hold your case, and how to hold your witness also. So
Right.
I just remember that experience.
I hope your experience, everybody is hearing you. And thank you so much for sharing it, Shraddha.
Thank you, ma'am. And it was a great experience to hear you also, because you are explaining in so we can say well draft words. It is so easy to understand as a newcomer. Thank you, ma'am.
Thank you. Anyone more? Anybody? We will end it for today. Thank you everybody for attending. See you tomorrow. Good night, everybody.
Good night, ma'am. Thank you.
Good night.